Sorry. So I'll be taking forward this. I will be moderating the discussion from here. Let's start with the first step, which is the creation of the ICC, and we'll take a few introductory questions first, and later on we'll get into more sophisticated issues and practical nuances. So let's start with, in which locations an ICC should be constituted by an organization.
It is, as per the law, it is to be constituted, of course, at the principal, the headquarters of a firm. But if the firm has more than one offices across the country or even in the same city, then they are required to have ICCs in all places. Typically, what I imagine, for the sake of convenience, should happen is that there should be one principal ICC, which could be set up in the headquarters. And in other locations, you would have to constitute ICCs as well. But just in order to keep some continuity, perhaps one member or perhaps the chairman or the co-chairman could be a person from headquarters, so that, because this is a very, very sensitive HR issue as well, and it is such a new matrix that it is going to evolve in the years to come. It would be very highly recommended that there is a continuity in all the ICCs that a firm might have across its various locations. So for that reason, my suggestion is that there should be also a co-chairperson who could therefore be privy to the proceedings across multiple locations that a firm might have, a company might have.
All right, and as per the law, only, yes ma'am, I'm here. So as per the law, but only in locations which have more than 10 workers.
No, that is the threshold. That is the threshold which the law prescribes, that for those organizations that have less than 10 employees, then the local complaints committee, which is to be designated by the government under this act, is the place where such complaints should be referred.
Correct.
Yeah.
As of now, ma'am, are you aware of any notifications that have created local complaints committees?
Well, I can only tell you presently about Delhi.
Yes.
About 15 days ago, I had the occasion to check up on this particular point, and I was informed that as yet, the government of Delhi, in any case, has not yet notified its LCC.
All right.
Yeah.
Okay. Now let's move on to the constitution, the composition of an ICC. So when an organization decides to create the ICC, what should be its composition? We have discussed this, I think, in an earlier webinar, but these are some introductory issues pertaining to the ICC. So let's sort of have them.
We have to follow the specifics that are laid down in the Act. It is important to know that what the Act mandates is the minimum that is expected of an employer. It is not an indication of the maximum. So the minimum that is prescribed is that there should be a chairperson. The chairperson should be a senior lady in the organization. There should be 2 other members from the organization, and there should be an independent member who is conversant with these sorts of matters, has had some experience in these matters, and particularly in context to the law of it all, and who's worked in the area. So it could be an NGO, a member of an NGO who need not necessarily be a lawyer, but has the experience to deal with these issues. So this means that the minimum requirement is 4 members. And those, amongst those 4 members, 50% must be women. So therefore you can have any number of members, for an example, let's say that you have got 4 locations across the country. Then you may choose to add people from different locations where in the overall context of the company, these are the members. And then therefore it makes it that much easier to deal with it cross-locationally.
So are you suggesting that there be common members for the ICCs, at least some members be common, for example, the presiding officer or the external member?
It could be a co-presiding. It could be a co-presiding because my experience is that unless, it is not always necessary that a presiding member has the time to be able to go translocational and then listen to the complaint. So sometimes it is a good idea to have a co-chairperson as well, so that there is no occasion when a complaint comes up for consideration and it is dealt with in an expeditious manner. Should not be for the lack of quorum or lack of chairperson.
Right. And what about the external member? Having a common external member is probably advantageous for organizations. Otherwise, there's a lot of, I believe, there's a lot of logistical effort required in identifying a separate external member in each city, especially in manufacturing locations.
Abhyuday, it depends company to company.
Right.
You could have a very experienced external member, because experienced external members for this purpose are few and far between, right? You might have lawyers who have taken up the cause in court for one party or the other party, either the complainant or accused, and so on and so forth. But those that have had experience in actually, over here, what is the ICC doing? It's really behaving like a court. It is the judge.
Right.
It is to be completely unbiased and objective. So that requires a certain bit of experience, and it is possible that a company finds such person and decides that translocationally in the country, that person would be the external member. So obviously there would be a cost attached if there is a requirement to travel to those out locations.
Right. And so what would be the obligations of an employer who has less than 10 employees in a specific location? We understand that they don't have to constitute ICCs, but there are other responsibilities.
With the exception that they don't have to constitute an ICC, all other obligations remain the same.
Right. So sensitization of employees, for example.
So it will first and foremost, Abhyuday, first and foremost, the obligation of the employer, and reference should be had to section 19 of the Act, is to provide a safe work environment for women at the workplace, which includes the safety from persons coming in contact with such employee in the workplace.
Correct.
And then prominently display in the company premises penal consequences of sexual harassment. Display the location where these complaints can be taken. So in this case, it will be the LCC because it's less than 10, or ICC as the case may be. Organize training workshops, awareness workshops, sensitization programs, and also training and awareness programs for senior levels of management.
Correct.
And there are several others that are listed. I mean, they're pretty sort of long and exhaustive. But even if you have 10, it is a good idea then to have at least your HR person in the company sensitized to these issues, so that if somebody comes amongst those 10 to say that, look, I've had this problem, at least that HR person is able to guide that individual. Because there's also the obligation that if there is a complaint, that the employer is required to guide such person to go to LCC or police, as the case may be, right?
True. All right, ma'am. That is very useful. Let's move on to the next part. So this is a tricky one, ma'am. So the presiding officer must be a senior level woman officer. Now, how should management identify persons who qualify at this rank? And what if a person of this rank is not there in the organization?
Look, it is sort of, I mean, I cannot understand the question. Every company will know who their senior personnel are.
Yes. Now, by a senior level woman officer.
Basically, look, I mean, basically what it is what is the Act trying to communicate? That there should be somebody of, senior level, somebody who has seen the way things are, somebody who is mature in being able to take a decision and able to evaluate facts, and somebody in whom, in general, the employees and people in the firm have a certain sense of confidence with. That is the first requirement. So that is the reason why And that's why they say that management will identify persons who will qualify as senior level. So it doesn't necessarily have to be your vice president if she's a lady, simply because she's vice president. It could be the number 3 or number 4 who's senior in that sense and may have a greater temperamental and objective and other skill sets that would be best suited for handling this post.
All right. And in case, you know, a person of that designation is not there, let's say in that company, but is there in a sister concern, would they be, can they appoint? Meaning that, let's say there are,
or a, yeah, yeah, sure.
A subsidiary, for example. Yeah, so if there are two companies, right?
Yeah.
So there are two companies, both of which are, you know, have a common holding company, and you want to appoint a presiding officer for one of the subsidiaries, and it so happens that there's a senior level woman officer who's there, who's handling responsibilities for another subsidiary, or who's there for the holding company. So she could be appointed as the presiding officer for this subsidiary company, right?
Correct, correct.
All right, ma'am. And so there was this other question about, in case there are no women in an office where there are more than 10 employees, what should be done?
Well, then I would imagine that an undertaking or an affidavit kind of document will have to be submitted to LCC detailing the fact that there are no women employees in that office, and therefore a committee is not being constituted.
All right, ma'am. Now let's move on to the appointment of the external member. We have already discussed that every ICC need not require a different external member as per the law, and a company has relative flexibility to choose that, as long as it appoints. Any organization has flexibility on that, as long as it has appointed an external member.
Yeah, important thing is that there must be an external member. Now, whether it's the same or whether they're occasionally sort of sourced, that depends. Hello?
And ma'am, another notion that is there with a lot of organizations is that the external member must be associated with an NGO as per the law. Okay, and
is this necessarily say NGO? It doesn't necessarily. What they mean is that such person should have worked in this field, should have knowledge of the field. It could be a lawyer. It also talks about that. The Act also talks about that. So it has to be an independent.
It could be a lawyer.
Yeah, it could be a lawyer. It could be a male.
Or it could be an HR expert.
Sorry?
It could even be a person who's a male, right?
Who's what?
Who's not. It is not necessary for the external member to be a woman.
No, it's not. It's not. In fact, it says only 50% of the ICC have to be women.
Right.
Yeah. In fact,
so,
I would suggest that it's a very good idea to have some gentlemen as members, because after all, there's a balance created.
Right.
It is possible, even though I'm sure you've noticed that this law is gender specific in context to the complainant. It has to do with women at workplace.
Right.
But in context to the respondent, that means the person who is being accused, it is not gender specific. It simply says a person, who could be a male or a female, of course, obviously.
Right.
So it helps to have some gentlemen on the committee as well.
So I'll just summarize this point. As long as the requisite skill sets are there, it is not necessary for the person to have been associated with an NGO, and also even an HR person with the right kind of experience could be an external member. Right, ma'am? There is no prohibition on that.
HR from the same firm? HR from the same firm?
From another entity altogether.
No, it cannot. Then, it cannot be somebody from another company.
Okay. So I'll give let's consider an example. Assume there's an accounting firm, and nearby, they have there is a management consultancy firm. So this accounting firm wants to create an ICC for itself, and they want to appoint the HR head of the management consultancy on
Yes.
as an external member. These two entities are unrelated.
Yes.
They are just maybe physically they have their offices nearby. And
Okay.
so it so happens that the accounting firm management knows of the management consultancy firm, and they know some of the people who work there. So is this something that would be possible? Let's
Now
assume
that
that the
HR person, whoever that person may be from the other firm, must be somebody who must also reply to the other requirements, which is that should have dealt with this, must be familiar with it, and all the other criteria. So if those criteria are fulfilled, then
it's
possible.
fine. Yes, then it's possible. Okay. So now this is an open question. Are there any best practices for appointment of ICC members? I mean, you've discussed some of these earlier, like how to constitute ICCs for multiple locations.
See, constitution is not a problem. And in context to best practices, the very best practice is that it should not have somebody where there is a conflict of interest.
Yes.
That external member's job is to be the external member and give proper, correct, objective views on whatever other facts placed before it. It cannot be somebody who is in a position to be manipulated for whatever reason. Then that is totally not a best practice.
Yes. Now I had a question. Assuming that the external member has also been engaged by the employer to conduct sensitization and capacity building for ICCs. Now, in that case, he or she is being remunerated by the employer.
Yes.
So, does this create any kind of conflicts, or this is fine, like as long as there is
I'll tell you what. If it is a case that the employer at the outset, when introducing the external member, also says that this person has a lot of experience, hands-on experience, and we have requested such person to kindly conduct training and awareness sessions so that all of us understand what it is that we have to do and what is our right and obligation. And then the firm pays for that. I mean, if there is a remuneration, 1 second, just hold on, Abhitya. Catherine, I'm in a call. This is put up front and there is a separate remuneration that is being given for conducting all these awareness programs, and that's the end of it. These programs are conducted, workshops are done, and that's the end of it. You get paid and that's over.
Right.
Then there should not be, but there must be transparency.
So what are the factors?
What will happen is that I'll tell you, if you invite somebody to do workshop, right, and then tomorrow the same person turns up, as there could be in the minds of many people to say that what is happening over here, and why were we not? There is a little gray area. So it's better to be upfront and say, okay, now this is the person we've chosen, so this is what it is, and such person will conduct your workshops.
So some kind of prior disclosure and a separation of remuneration for both training versus sitting fee as external member, that should be done.
That is right.
Okay. And I wanted to ask you something on your suggestion that there should be a continuity between different ICCs. So there should be a sort of a lead or a head ICC, which a central ICC which coordinates the activities of the other ICCs. So any pointers on what would be the sort of
I wouldn't say so much coordination, excepting that it is in my experience, it is very important for headquarters to have knowledge of such kinds of emerging HR situations, because these are of very sensitive and serious nature and the repercussions can be enormous.
True.
So that is the reason why my suggestion is that somebody senior, somebody objective, or not senior, but certainly objective and experienced from headquarters be somehow linked with all the other locations, so that anything that is emerging in this matter comes immediately to the knowledge and attention of headquarters, that this is what is happening. You don't want something exploding in your face.
All right.
Yeah.
That is perfect. So we have already answered the first question, that the external member could be a man or a woman, as long as 50% of the committee members are women and as long as the presiding officer is a woman.
Yeah.
My next question, ma'am, was on the remuneration of the external member. So what are the prescriptions under the Act?
Well, I mean, the prescription under the Act is the minimum prescription, which is some 200 rupees and some train fare and all this sort of thing.
Yes.
I mean, I don't know what more I can say.
Is it realistically possible for organizations to get an external member at that?
Listen, everything in life is possible.
Okay.
So if a company chooses to cut costs and thinks that, okay, let's do the 200 thing, good.
Okay.
Yeah.
Then there was another question on what is, how do we determine, how should the management determine about a person's familiarity with issues relating to sexual harassment? For example, I mean, what kinds of prior experience can we look at? We have some criteria written under the law, like let's say there is a person who has worked on women's issues or worked in an NGO for some time. That is one criterion. Are there any other ways? Because this is sort of.
I would imagine that the CV of the person who's under consideration should be able to, and certainly during an interview, it will have to also be an interview where such a person will have to be queried about different propositions, you know, what will happen if this happens or that happens. So from that, I'm sure anybody who's talking will be able to gauge the degree of experience and knowledge that such a person has.
True. So that is actually
subjective.
Yes, yes. But in terms of, I don't know, I mean, if one is to demonstrate to regulators or inspectors that, you know, we have constituted our ICC according to the law, in that case one cannot take recourse to the interview one conducted. Although at a practical level this is a very good way to measure the external member's level of expertise. So on paper, in terms of qualifications, are there any pointers you can think of offhand?
Look, I mean, you know, NGOs that are dealing in this area, sexual harassment and gender rights, are well known. You can Google and find out which those are, you know. Some names are also very well known. So, I mean, those are objective pointers that, you know, you do a little bit of research, somebody saying NGO. Well, a good idea would be to simply Google the name of that NGO and see what do they do precisely.
Right.
And in what way have they been involved in gender justice issues?
True.
You know, those kind of tools, one would have to be a little creative to see. It's the same thing as when you hire somebody in a firm. You do background check, don't you? Yeah.
Yes, yes. So you can't take it, you know, take it to be a hard letter that, okay, this reflects your expertise. One has to actually find this out. Make a subjective
call.
Well,
this would be, I imagine it's standard. I mean, I don't think any company needs to be told that clearly. They have to check out. Yeah.
True. Okay, let's move on to how the ICC should conduct its proceedings. I think this is the most technical part of the entire session and the third part. In the meanwhile, if participants have any questions, they should email. They should write those to us in the chat box that is there, and we can ask Ranjana ma'am the question. So first, the broad question, ma'am: what is the decision-making process that the ICC should follow? What is the legal requirement? And if we can have a broad outline of steps, it will be great, of the different stages before it comes to a decision.
Look, what the law says and what jurisprudence demands is natural justice. Now, what does natural justice means? It means that both parties must be given the opportunity to personal hearing and to be able to represent their case, have a discussion or a hearing being given to them to be able to state what their problem is, what their issues are, to be able to adduce evidence and to produce witnesses in support of whatever they are saying. So therefore, now just to, what would be the steps. So now here is a lady who has thought that she's got a problem and she wishes to file a complaint with her ICC, right? Now, even before she thinks that she wants to file a complaint, she might just simply want to go and talk to somebody in the ICC to say that, look, this is what I think is the issue and what is it that I can do about it. So typically the first stage is a person with a complaint wanting to, at least as a sounding board if nothing else, in a very, very early preliminary stage, be able to talk to somebody and say that, oh, this is what has happened. So what is it that I should do? In context to the ICC, the law is very clear. Unless they have a written complaint, they're not in a position to go any further. And why is that? Because if I were to simply come and make a complaint against you, Abhyudaya, it would be hearsay. If this is factually correct, then I should be able to stand by what I say by committing it to writing. And for that written complaint to be transmitted to you for your comments, right? That means that you as the accused, if I was sitting in ICC, I can't make up my mind that, Abhyudaya Agarwal is definitely the accused, definitely he's done all of these things.
Right.
Right? So, irrespective of what my personal views about you, I cannot, as member of ICC, and there's a huge fiduciary duty that is attached to every member of the ICC, to be absolutely objective and transparent. So this complaint which has been given in writing must be transmitted to the alleged accused. And that person must have the opportunity to file a reply and also for personal hearing. This is cardinal.
Right. So there was a sort of a pre-filing counseling session which an organization can provide for assistance.
Yes.
Then of course there will be the filing of the complaint and
Yes.
an opportunity
and
given
remember
to
that the complaint has to be filed, 6 copies of the complaint
yes.
have to be filed, and with the name of witnesses and documents that are being adduced as evidence in support of that complaint, 6 copies of all of that, because one
Right.
full set will be given to the alleged accused, who will equally be permitted to respond in writing and to adduce his evidences and witnesses, and he must file
Right.
6 copies too.
Can the organization
there is
help
a lot
with the
of, Abhyudaya, there is a lot of paperwork and procedural requirements in actually implementing and working the ICC. It's
Right.
pretty complex. Once you get used to it, of course, it's not difficult, but it's pretty complex. And for such companies as are inclined to have proper training workshops for the members of their ICC for capacity building would be a very, very good idea.
Right.
Yeah.
This was a broader outline of the steps.
Yeah.
Of course, this decision-making process can get very nuanced. When an ICC
Yes,
is to
that's right.
actually, when it is to come to a conclusion about which of the allegations is adequately substantiated and which one is not, that
Yes.
requires a very detailed understanding of
Yes.
the principles of evidence and
Yes,
other
that's right.
areas of law.
That's right.
So, all right, but these steps, at the very minimum, at least ensure that requirements of natural justice have been met and each party has been given
and everything that is submitted in writing has to be given to the opposite party, a copy of it. There's
right.
total transparency to be maintained.
True.
Right?
Is it the responsibility merely of the complainant to make all those copies, or can organizations provide those that kind of logistical assistance?
Look,
is it
the organization will have to provide logistic assistance. That's also part of what the law says, right? That they will
Right.
provide support. Thing is this, that even though the complainant is going to file 6 copies, so now you think about it, supposing there's an ICC which has 4 people, because that's the mandatory minimum requirement, right? So
Right.
1 copy to each of the members?
Right.
right? One copy will go to the opposite party.
Yes.
So that in 4 plus 1, 5, and one you will keep in court record, in your, not court record, but your office
ICC
record, I
record.
mean for this,
Right.
because there's an ICC office which will maintain its documentations.
True.
Similarly, when that written response comes, there will be the 6.
Right.
Each member must have a complete file to be able to, apply their mind to it.
True.
Yeah, so all this logistic support is certainly the obligation of the employer to provide.
All right. And in terms of the records that should be maintained by the ICC, so all these, written documents.
So therefore, your court, like you have a court file, Abhidya.
Yes.
With all what we call pleadings as lawyers.
True.
As well as whatever are the orders, because there is nothing in the law that suggests that you have to have these many hearings or you have to have those many hearings. The ICC on a case-to-case basis will decide how many hearings have to be held in order to get to the bottom of the whole matter, in order for them to evaluate evidences and whatever it is that both parties and their witnesses have said, and then be able to take a call on whether it is substantiated or whether it is not substantiated. So the file will become a complete file, the whole story from the beginning to the end. It is on the basis of these findings that the ICC will make recommendations to the employer of what is the action that needs to be taken. And it is the employer's obligation to take those actions and in writing inform ICC that this has been done. Only then that file will become closed.
Right. And the components of this file would be, so the pleadings of the parties as the complainant and the defense submitted by the defendant. Any statements given by
the witnesses, any documentary evidences, everything, every
and all the orders passed by the
ICC. Yes, absolutely.
Right. So this would be a typical file, that
it is a typical file. Yeah.
Right. Would you want to? Would you be able to give any pointers, ma'am? Any introductory pointers on appreciation of evidence, or is that very technical for this?
No, it's very technical. For it is not possible to. Appreciation of evidence, of course, you're not following the strict rules as far as the Evidence Act is concerned. But certainly evidences can be testimonials from witnesses, and ICC is free to query the witnesses.
Right.
Yeah. So it could be by way of just documentary evidence of something or the other, whatever, maybe text messages, whatever it may be, which will have to be validated.
Okay, so procedurally we have discussed what should be there, and in terms of really coming to a decision, that's a subjective skill. So ICC should make sure that
it's not subjective. That decision, no, Abhyudaya, nothing over here is subjective.
No, I mean it's like yes.
Yeah,
it's a skill that can't be learned from a book.
It can't be learned from a book. It can't be learned from a book, and that is perhaps the reason why they are saying, perhaps, I mean, this is just my conjecture, that there should be an independent member who's familiar with this whole entire matter and how it happens.
Right.
Because then at least that person is in a position to guide the members of ICC that, look, this is what the procedure is. This is the way in which we need to evaluate. This is how the proceeding, we should conduct the proceeding in this particular manner. Why? Because it has to be to the satisfaction of both parties. It has to be to the satisfaction of both parties. To the, to the best of the ability of the ICC, it should be to the satisfaction. I mean, there may be one party against whom the ICC's finding might want to appeal. That's a different matter.
All right. My worry is more on the lines of that, there are 60,000 new companies being registered every year, if you see the MCA data, and there are around 3 crore SMEs as per records, if you see anywhere on the internet. So that external members who are familiar with this kind of work in that kind of number, finding them is really difficult task.
And you could have an external member who, who happens to be the external member for 3 or 4 companies,
Yeah,
Abhidya.
that's fine. That's
Gradually,
fine.
over a period of time, that capacity may get built up.
Yes, yes. It's over a period of time that we can expect this to happen. Till then, because we
However,
see
the company, a company which might have registered itself yesterday and might have more than 10 employees must have one.
Right.
Must have an ICCI. They have to be compliant with the law. So
True.
there will be
There is
that
no
time gap.
excuse.
That
Right.
is given. Yeah.
Yeah, there may be just some amount of time required in this entire
That's right.
process.
That's right.
That is it. Ma'am, could you please elaborate on the role of the ICC with respect to the conciliation process?
Look, in law, in the practice of law, it has now become mandatory when we're doing contracts or that you must first explore the possibility of conciliation rather than, going straight to the courts and to arbitration, right? That conciliation has become part of your contracts now. So
Right.
here also, while it is not, see, this is a very fine sort of a line, right? A person who is a complainant may fully understand what that conciliation means or may not fully understand. So it is for ICC to into the knowledge, inform her and explain to her that, look, this is a possibility, conciliation, and this means that perhaps, like an out of court without going into inquiry, you evaluate and see whether you would like to settle the matter with this person who is accused. If he gives you an assurance or whatever, however, provided that the settlement does not involve any monetary compensation. Now, ICC must be extremely cautious and careful not to seem as if they are coercing or strongly suggesting that course of action for the complainant.
Okay.
The complainant must be sent back home then after this session where you sort of say that, look, here is an option, this is what happens, so on and so forth. Let her come back the next day perhaps, or however, and say, look, I've thought about it and I do wish to go for conciliation. I want to explore the possibility. In which case she must make an application in writing requesting that ICC suggest help, assist in the matter of conciliation. In which case after her complaint has come...
application will be necessary, ma'am?
Of course, written application. Without that, कल को वो कहे कि भाई साहब इन्होंने हमको जबरदस्ती से करवाया.
Right.
And the law says that it must be on the written request, it says.
Yes.
The words are on the written request of the complainant.
Right.
Right. So after that, in any case, you would have given a copy of the complaint to the opposite party, to the alleged accused, and you will invite him, you will issue a summons to him and call him and tell him, look, this is the thing, and this complainant is desirous of exploring the possibility of a conciliation. Are you agreeable to it? And you'll have to give him a day or so, or 2 days, whatever it may be, to think about it and come back and say that he's open to conciliation or not.
All right.
Both parties have to agree.
What would be the...
He must also similarly write and say that he has been informed about the, the desire of the complainant to explore the possibility of conciliation, and that he is happy to explore such possibility.
Okay. And what should be the outcome of the conciliation process? In the sense, are there some action points, and what will be the document also called?
No,
it will be
the thing is this, that both parties then have to arrive at at whatever is their understanding of settlement as between themselves. The ICC will have to tell them that, okay, now you go into that particular room and you sit down and you work out whatever it is and however you want to settle, provided it does not involve monetary compensation.
Right.
And you come back and you tell us what your terms of settlement are. Then the ICC will record those terms of settlement. Read them out to these people and say that, is this what you have said? Are these the terms of settlement? If they say yes, you will take a signature of both parties with date on that note sheet, and that will become the terms of settlement. But
As a
remember
point,
this,
right, true.
remember that the law also provides that if the person who is accused reneges on his commitment to honor those terms of settlement, then the lady can come back and ICC can then proceed to inquiry.
Yes. Well, I had a question that ordinarily, you know, when a complainant who is not familiar much with law, I mean, she would not know what to suggest as a term of a settlement. She would just say, all right, I agree to forgive you, and you know, it's fine, that is one way. Now, many people will not be willing to settle on those terms. So, what is typically a settlement like? We assume we throw monetary amounts out of the window. We cannot consider those.
I'll tell you, I can only tell you by way of an example.
Yes, that
where there was a person who was a secretary who was a little upset with somebody in another department who had a familiar way of speaking.
Okay.
And she was offended by this particular way of speaking and complained that, you know, I don't like the way he talks to me and I'm not his friend and there is no reason, so on, so forth, so forth. And the solution that was found was that, okay, fine. Now you're offended, fair enough, that is perfectly legitimate. We suggest that you call this guy into, let's say, the boardroom, for example, and tell him that, listen to me, I do not like this. So please do not, you know, be familiar with me at all. Just keep a professional relationship, because if you don't, then I'm going to have to bring this to somebody higher up. And she did that and it stopped. So very often what happens is that even a person who is sort of the alleged accuser or accused, sometimes there is, you know, cultural sensitivities, if you see what I mean, and may not even be aware that what he's saying by way of being just very friendly with his co-worker amounts to an offense to the other person. Right. So it is always a good idea for people at not, well, to have a sounding board. You know, if there is something that a lady is a little irritated or offended or rattled with, should be able to go and speak to somebody and say, no, this is what it is. It helps. Correct. It helps to nip matters in the bud rather than let them go to an extreme level.
True. Let's move on. So we've received a few questions. I will ask them after the next set of questions.
All right.
In terms of monetary settlement, I think the Act has language to the effect that it should not be the basis of conciliation. But would you suggest absolutely no sum, or are nominal sums or costs okay?
Nothing.
Zero.
The Act says no, it means it is no.
Okay. Ma'am, could you explain the risk that an organization faces in the event the ICC does not follow these decision-making procedures? We just went through the entire detailed procedure that should be followed, you know, steps that should be taken. Now, say there are flaws in that procedure. Maybe an employer has failed to adequately train the ICC, and because of which you realize that the files have been improperly kept, or you know, there is no way. It so appears that the ICC has arrived at a decision without appropriately recording the submissions of the parties. What kind of legal risk is there? There is tremendous reputational risk. We understand that if this information is taken, you know, to the press or if it is known. But what is the legal risk? For which court would typically handle this matter?
See, it doesn't matter which court deals with it. Abhyuday, it doesn't at all matter which court deals with it. What would happen is that if one of the parties is of the view that these people have not followed the law the way that it ought to be, they did not record, they did not give me natural, whatever it may be, they are perfectly capable of taking the matter to the court, which will be a civil court.
Right.
And say that this is what has happened to me, this is what my case is, this is what I did, I have exhausted the remedy that was available to me as an employee of this organization. However, the organization has behaved in XYZ manner. In which case, notices will be sent by the court to the organization. The records of the ICC proceedings, and that's why I say that you must maintain your records properly, will be summoned by the court.
Right.
And if they find that, you know, you have sort of taken shortcuts in the whole matter, because there is no reason Ignorance is not a defense in law, as you know.
Correct, correct.
You can't possibly say that I had no idea that I had to do this.
Correct.
In any case, it's not going to do, you're not doing yourself a favor by coming up with such an excuse. Then there are penalties. And the penalties go to all kinds of extreme extents, including cancellation and all that, of registration and so on. You know?
Right.
So it's better, you know. You don't want to be
True.
penny wise and pound foolish, so to speak.
This would be basically, you know, litigation for wrongful termination of the employment contract, or wrongfully, you
Why?
know.
No, wrongful termination of employment contract in context to a sexual harassment.
Yes.
In context
So let's say,
yeah.
correct. So let's just explain through a situation, assuming that a defendant has been, a salary cut has been recommended by the ICC against a defendant. And that's when a defendant is not happy. He says that, you know, this ICC has not followed the procedures correctly and I want to go to court. So what is the type of claim that he will typically file? That is what I just wanted to explain.
Damages.
Okay.
Look, there are two things that you said here. One is that the ICC has evaluated everything and has reached the conclusion that there has to be a penalty imposed on the gentleman. Let's assume
Correct.
It's a gentleman or a woman, as the case may be.
Yes.
And that this much has to be cut, everyone, from the salary till the dues are paid up, right?
Right.
That person is upset and doesn't want this to happen, and therefore challenges the order. He is perfectly within his right to challenge that order.
Right.
But to say that the ICC did not, he can say that the ICC did not follow, but the evaluation by the court into the records of ICC will bring out very clearly whether proper procedure and natural justice has been fully dispensed or not.
Right.
In which case the person who has come to court with a complaint is going to be thrown out.
Yeah, that's fine. So one is the right of appeal, right?
Yep.
You just appeal
Yep.
against the decision of the ICC and say that, you know,
Yes.
that is one thing. I was talking of the employment litigation angle, like the risk that an employer faces if his ICC is not functioning properly. So what I'm asking for the ground of the complaint.
The ground of the complaint is that the ICC is not functioning properly as per the law act. No, that is the ground.
All right. And okay, we'll move on to the next question. What are the powers or what actions should an ICC take in case a complainant or a defendant or a witness, these are three different entities, so if any of them is not attending or participating in the ICC proceedings, what is the opportunity that should be given to them to attend, and in their absence or failure to attend, what are the powers of the ICC?
Look, if two aspects. One is if somebody files a written complaint and subsequent summons go unanswered, the person doesn't turn up, the lady doesn't come.
Right.
Typically what should happen is that 3 opportunities should be granted by the ICC to have the lady come and defend her complaint. If, for example, she does not come, or even on the 4th date of hearing, then it should be simply dismissed in default as it happens in court.
Right.
If the person who has filed a complaint is not desirous of pursuing it, then there is nothing that the ICC can do to force her to pursue it.
Right.
So therefore, when you send a summons, you will say that, you know, you have not come on these 3 occasions, 1, 2, 3, whatever the dates. We are holding the 4th. If you do not come, kindly know that we will pass an ex parte order to dismiss your complaint in default on grounds of non-pursuance of the complaint. But you must make that recording very, very properly and correctly, because in case she goes into goes to the court and says that I had filed a complaint and never bothered, then all these summons that you send, giving her opportunity to come and present herself, natural justice, without being over hasty and saying, well, she didn't come the last time, let's dismiss, that kind of thing. Reasonable period must be given, is fully recorded. So even if your file gets summoned by the court, there is no difficulty. And
All
on the
right.
side of the accused, if he does not turn up for three occasions, then on the fourth, again, you're going to tell him that you have the ability under the Act to pass ex parte order. It is almost like
Right.
an assumption of guilt. Then
Right.
there is a lot of provision about all the different things that can be done, actions that can be taken.
Correct, if that's true. And what can be done to ensure the presence of witnesses?
Well, you will ask for the witness. Again, the witness will be also asked 2-3 times to come, 3 times at least. Doesn't come. Then you have to, whoever gave the name of that witness, supposing it's a complainant, then you'll have to say that, your witness has not come. We're giving this last opportunity. You make sure, otherwise you will withdraw the name of this witness from your list of witnesses. And
All
you
right,
will
because
make all your recordings very, yeah.
Okay, because usually this is a big problem, no, because witnesses don't have anything to personally to do with the case, like they are neither the complainant nor the defendant, and you have in criminal investigations is
let
the
me tell you
problem.
that my experience has been at the Women's Commission that people who are genuinely sort of concerned with the whole thing and are requested to be witnesses, once they've made up their mind to be witnesses, they do come. They do come. And in the Women's Commission, it was not a case of employees. So the commission had no control over the people who are complaining or those that were accused. And no control over the witnesses either. But people were coming from long distances to provide testimonial, for in favor of or against, as the case may be. That is not the case.
All right. So in case that I'll just summarize this discussion. One is that if the complainant is not present, sufficient opportunity will be given, of course, to be present, which is up to 3 hearings, up to 3 opportunities can be given by the ICC. If the complainant still remains absent, the ICC can dismiss the case, and it will be called for want of prosecution. That's the technical term, right? For non-prosecution of the case. And
for what shall we say, prosecution to not pursuing, non-pursuance or not pursuing the complaint despite repeated summons or whatever.
And in case the defendant is absent, then the ICC, after giving 3 opportunities to be present on 3 separate days, can proceed to decide the case independently in the absence of the defendant.
On the fourth date.
On the 4th date.
Yeah.
This is known as an
ex parte opportunities must be given, right?
Yes. Yeah. So this is known as an ex parte decision, where the ICC will
and it is provided in the Act. Yeah, it's provided in the Act.
Yes.
Yeah.
And if a witness refuses to attend proceedings, well, that then the ICC can request, will advise the complainant or the defendant to strike the witness's name off. Basically, because the testimony of that witness cannot be taken. So I had another question, ma'am. So we just want, for the purpose of clarification, because when there are organizations with multiple offices, I know, so the law is very clear that every workplace which has more than 10 employees needs to have an ICC constituted for itself. Now, what a lot of companies, have thought of is that make the ICC available. So constitute one ICC and make it available everywhere, in the sense that, let employees write an email to the ICC, which is at the central office, or have jurisdictional level, state level or regional ICCs, instead of having ICCs at all the places where more than 10 people are there. Instead of that, they have just created regional level ICCs or a central ICC. So there are 2 ways they are handling the complaints process. They either allow the employees to file a complaint through email, and then maybe they could be transported at the expense of the company to the location of the ICC, or alternately they make the ICC relocate to where the complaint has arisen, so that the employee has no trouble. Now, are these practices consistent with the law, according to you?
Yeah, I think so. I think they are broadly consistent with the law, because there is a practical difficulty. I mean, you can have, designate 1 or 2 persons in your location outside to be members, I mean, it makes sense to have some members from your outside location who are also members of the ICC of the headquarters, right? Because if there is a problem over there in that location, there is at least one person who is available to speak to that. You know, like I said, that in the initial, very early stages, very often these persons, ladies, want to talk to somebody.
Yes.
And say that, this is what my problem is. This is what I think is happening, right? Or there might be an emergency situation. You see the kind of assistance that has to be given to the complainant, the lady who's a complainant. Whether it is physical infirmity, mental infirmity, psychiatric, death. Look at the full range. So my advice would be that in the central ICC, don't limit yourself to 4 people. Add some people from your different locations, so that at least there's a points person. And after that, the way that is being said that, you know, either the ICC can go to the location, that makes more sense. But what happens is that a hearing typically goes on for at least 3 hours. My experience of several years with the Women's Commission. And you can't tell a person to stop talking.
Yes.
You know, when they get into the flow of it, then it just simply goes on. Similarly for the person who's accused. So you can't cut short the whole thing, sometimes 3.5 hours. At least in the initial, you know, in the first 1 or 2 hearings, because then everything has to be said, right? A lot of it may be relevant and a lot of it may not be relevant. A lot of it is in fact not relevant and to the point to the complaint. But it becomes very difficult to tell somebody that, you know, can you please cut the flab and get to the point. It's because they're already so emotionally charged. It is a very intensive experience, Abhyudaya.
True.
So it makes sense to have 1 or 2 people, maybe a HR person or somebody else other than HR at the location.
1 second. So let me summarize the points from this discussion. One point is that there should be a local point of contact whom at least employees can speak to. This is not a full-fledged committee, but, you know, sort of a counseling or an HR or an ombudsman.
That person can be co-opted to be a member of ICC of the company.
Yes. Yeah. Correct. Now, this is one part of the story. The other was, sorry, the other already relates to what we spoke earlier, that there can be an external member and a presiding officer who may be required to relocate themselves depending on where the case has arisen. But I am talking of another situation, a third situation where, let's say there's a local point of contact, but the committee does not exist in that office, although there are 10 people. The committee does not physically exist there, but it is possible for employees to complain via email or other mechanisms, and either they will be taken to the central committee or the central committee will completely come there, you know, relocate it.
So you will have to say that the committee exists in all locations because people from all locations are co-opted.
Okay.
All right. And then perhaps because there is, you know, this concept of fiduciary duty and confidentiality, it therefore makes sense for an email ID pertaining to this particular thing, you know, sexual complaint, harassment complaint, which will then be transmitted to all the ICC members. Then the chairperson will say, okay, now let's say that it's, you know, the problem has arisen, let's say in our Nagpur office. And you have person X who's designated over there. And so my chairperson, because I'm very busy on those dates, can go to Nagpur and are outside. But always it makes sense, therefore, to have 2 persons co-opted in every location. Why? Because you have to have a minimum of 4 people.
Right.
You know what I'm saying? The minimum prescription is 4, of which 1 is the outside, right?
So of course you are suggesting that, no, so then we have to co-opt 2 people from every location, otherwise it's a violation at least.
Exactly, because unless you have 4, the person is going to be aggrieved and say that they're not following the law the way that the law says it should be followed.
Yes.
It doesn't say that all 4 members have to live in the same city where this ICC is.
No. But if there is but if there is a matter in Bangalore and there is no one from the Bangalore office and an employee has to complain to the ICC in Delhi, which has no one from the Bangalore office, there is a problem, right?
It will become a big problem for the firm. Can you imagine
Legally,
that
I'm
4
saying.
people are going to be flown now to Bangalore
Yes.
for at least a minimum of 2 days? It's, I mean, it just will become very difficult.
True.
I mean, practical terms में मुश्किल हो जाएगा ऐसा.
True. All right. So, Mitali from CII just asked us to revise this point because I think this is something that a lot of companies have been grappling with. So I'll just quickly revise it. So where organizations have multiple offices and these offices have more than 10 people, legally they're required to have an ICC for such offices. So what we discussed is it all right for an organization to just constitute a central ICC and which is situated only at the head office and have all the employees from any location, complain, say through an email or through through technological mean to the central ICC. Now the answer is, so what Ranjana ma'am has suggested is that there should be, and this is required under the law also, that there should be 2 members locally co-opted from each location.
No, Abhida, let me correct you. The law does not provide that there should be 2 members at location. Law requires that there are 4 members in every ICC. So if you have a central ICC
from the office, from the workplace.
Yes. So if every location has 2, then all you have to do is to fly out the chairperson and your external member.
Right. So 2 members become from the specific workplace where the ICC is being constituted. And this has been written in the law that 2 members should be from the workplace.
Yes, there have to be 2 members from the workplace. Now it doesn't say which workplace, any workplace. So it fulfills that.
Okay. So so this is how we should organizations can set up their ICCs. Now, ma'am, what is your view on technological participation? One second. So Mitali has asked us another question. Can these 2 members who are from the workplace be male as well? Well, Mitali, the answer is as long as the as long as the overall composition of the ICC. One second, let me just check. This is subject to the rule.
You have to have 50% women. So yes. If your chairperson has to be a woman, and if your external member is a woman, then that's fine. You can have 2 male members from the location. Or if your external member is a man, then you will have 2 women, because 50% for 1 man and 1 woman. You will have to ensure that 50-50. 50% of
50% is the only
have to be women. Yeah, including the chairperson.
Yes. Yeah. Now, what are your views on technological participation in ICC proceedings? Because this can reduce travel costs, logistical hassles, time, everything. So to what extent should...
I think that in this day and age, I think if you are able to have a video conferencing,
yes.
I think it should be perfectly possible.
All right. So video conferencing for hearing parties, taking oral evidence, that's fine.
Yeah, because all these members have to be present, in the sense that doesn't mean their bodies have to be over there, but that they should be participating in that, and that the complainant and the alleged accused have an opportunity to be able to talk to all 4 of them.
Yes. And per hearing, what is the requirement of how many members should be present?
4.
All of them should be present in the...
ICC is required to hear. Yeah.
Right. Okay. This question we have discussed, what can be done if a party is dissatisfied with the appeal? There are 2 aspects to it. One is the way the proceedings have been carried out, and another would be the outcome, right?
Yeah.
So if there is dissatisfaction with the functioning of the ICC, then there's a separate kind of complaint for non-compliance with the Act. But if there is dissatisfaction with the decision of the ICC, then a right to appeal has been provided.
Yeah.
Ma'am, you had some comments on this right to appeal as to who is the authority whom they can go to. If you could share it with our audience.
Right to appeal in the first instance is to the ICC itself. You know, if for example I have said that, you know, you come up with something like, all right, so you will cut 10,000 rupees,
Right.
right, from this person's salary, then
Right.
the right to appeal will, of course, lie with the metropolitan magistrate or the judicial magistrate first class. But it is only in context to whether the finding says that the allegation is not true, that is section 13(2),
Right.
whether action for sexual harassment is misconduct as per service rules, I mean that person is dissatisfied with, that is 13(3), action for deducting salary or wages, false or malicious complaint, then that means that if it's a false or malicious complaint, then that appeal will be against ICC for finding it to be false and malicious. False evidence of production of forged or misleading documents by witness, contravention of section 16, that is disclosure of information about the complainant or any aspect. It is only on these grounds, if there is dissatisfaction, then an appeal against the ICC findings will be filed in the court of the MM or judicial magistrate, MM or JM.
Metropolitan magistrate in metropolitan
Or
areas and judicial magistrate
first
in other
class.
areas.
Yeah.
Right. Judicial magistrate of the first class in other areas.
Mm.
Now, what about the right to appeal, the base, not on these grounds, just on the finding of guilt or innocence?
No,
there is the authority notified under.
If that guilt is,
Yes.
if the allegation is not proved, I just read out to you.
Yeah.
Look at section 13, 14 and 17.
Yes. And what about the right to appeal to the notified authority under the Standing Orders Act? That
notified authority, no, then you appeal over there if it's a factory or whatever. Okay. But at this present point in time, I don't think government has notified anybody.
Yes.
Yeah.
Now a practical issue.
Yeah.
What should be, I mean, before filing a sexual harassment complaint, what should be the pros and cons that, I mean, the negative sides that a complainant should weigh before filing one? Because
look,
say there
I mean, I don't know what kind of a question that is.
In terms of what can the repercussions be, although there is a legal requirement to ensure confidentiality, right? But you don't know what kind of career opportunities she is losing, a complainant. This is a serious matter, of course.
I would imagine that it depends on what company this person is working in, the maturity of the company per se. That is, what is the credo they follow, and what is the maturity and objectivity of their senior management.
Right.
So if it is, it is a very, very subjective thing.
True.
How can you say what she should consider or not consider? She will be considering her survival, forget about her job.
Yeah.
Typically, that is what will happen. I mean, even in the small example that I quoted to you of some administrative staff, you know, finding her major concern was exactly this.
Right.
Whether you know, whether there can be a little bit of a revenge, or whether this person will, you know, spread scurrilous stories. It depends on who can. I mean, how can, it's impossible to predict.
Yeah.
Anything can happen. But then if something like this is happening on the part of the accused and the senior management knows that this is happening or it's brought to their notice, it depends on the maturity of the senior management of the company of how they're going to deal with it. But if they say that, no, the accused is a very important guy for us, you know, let's try and hush it up, well, that's their prerogative to do. What can I say?
Right, right. Yeah. So that is a sort of, you know,
yeah, it's a very gray area. It's a very sensitive area, and also the most difficult part, I think.
Right.
Yeah.
Just for clarification, Mithali has asked again, is it necessary for the external member to be present during every hearing of the ICC?
Yes.
The answer is yes. The entire ICC should be hearing the cases.
The whole point is to bring objectivity to the proceedings, right?
Sorry.
And a completely unconnected, completely unconnected voice to the ICC. That is the reason why you need an external member. So of course every proceeding.
True. I had a question related to this. There are a lot of organizations which have constituted ICCs which are very large. Say they have 8 or sometimes 9 members. In that case also, then doesn't that mean that they're taking up a lot of burden on themselves because they'll have to ensure the presence of the entire ICC again?
Yeah.
That is true, right?
But also, if you have, let's say, 8, 9, 10 members, whatever, translocationally, let's say you got 15 members in that ICC. Then, if there is a case that is being handled by 4 persons, then 2 people are, of course, constant. One is the chairperson, one is the outside. The other 2 people must remain engaged with that particular case till it finishes. It is not advisable to say that, okay, now these 2 aren't available today, let's send the other 2. Because they have to read everything again and they will bring a different approach to it. There has to be consistency in the way that the ICC is going to deal with proceedings.
Correct. So in this case, but you said that there could be a sort of bifurcation or division of cases between the ICC members, so long as all the ICC members to whom the case is allocated, including the president and the external member, they should stay there for every year.
Correct. Yeah.
But that need not mean that all 8 members have to hear each and every case.
No. Yes, your minimum requirement is 4.
Yes.
Yeah.
Great. So is leave that is granted by an ICC on the interim leave, is that counted towards paid leave? The Act says it is in addition to the statutory or contractual leaves that a worker should be entitled. So this would be paid leave.
It's in addition to. It's in addition to.
Yes.
Yeah.
So as an additional measure, say if the complainant is in a secure state and she's happy with the leave and psychologically she's not disturbed, is it all right if the ICC suggests that leaves it to the employer to give any work or collaborate on any project?
You cannot leave it to the employer to give work. If there is a request from the employer to say that could you please check up whether she is open to, even if she's on leave, whether she can work from home, because in this day of computers, that may be a possibility, then it is the ICC that must request. And it should be properly recorded.
So what should be the order of communication? The employer can request the ICC?
Yes, in writing.
Right.
To say that, is it possible for you to query and ask this question?
And the ICC will have to ask the complainant and take her written consent sort of.
Absolutely. Yeah. And record it in the finding.
Right.
And important to,
Otherwise there will be a problem again if these things go unrecorded. True.
No. Everything must be recorded.
Yes. So another question, we've already actually discussed it in passing, but we'll just revise it. Whether the ICC can take cognizance of oral complaints or instances it comes to know of through the members on its own, not through a written complaint that's filed by the complainant.
ICC will get to know only when there is a complaint.
Yes, that's the process.
ICC does not have eyes.
Yes.
So when ICC gets a complaint and a written complaint, then, however, if in the first instance a lady wishes to speak to a member of ICC just to, to run some thoughts by such member, then that opportunity of being heard must be afforded.
True. What is the frequency that which ICC would typically meet? One is that it would meet for hearing cases, definitely. Apart from that,
it would meet for finalizing its report and making its recommendations.
Right. Before we move to the next, move ahead, I think it will be important if we can address a few questions that were asked by the participants.
Yeah.
So One question was by Ms. Rita Saxena about whether a complaint can be filed against a woman by another woman under this act. So
yeah, well, as I said, that the act says that the respondent, that is to say a person who's accused, is a person.
right.
It doesn't say a man. Yeah, yeah. So it's gender neutral in as far as the respondent is concerned.
Right. Okay, there is another question by Ms. Rita again. If a complaints committee finds out that this is workplace harassment but not sexual harassment, what can it do? So,
well, then in that case, the ICC must make a finding to say that the facts and circumstances narrated and the written complaint given do not indicate or do not reveal any element of sexual harassment as contemplated under the Act. That is to say, it does not have, all the different things that are given over there. Either sexual harassment itself or circumstances that are construed to be sexual harassment. As such, ICC cannot proceed with the case, and we recommend that the complainant approach HR committee, HR manager, or whoever is the HR person.
right. Many organizations have a code of conduct for employees, so maybe the
Good
ICC
idea.
can redirect.
Good idea. Good idea.
Yeah. So in that case, the ICC could sort of cooperate and redirect the employee there after making its findings.
Do you know, Abhyuday, that in many companies they have a code of conduct, one element of which is that if there is somebody carrying on an affair with somebody in the company, that person has to resign.
Yes, yes, I'm aware.
Yes, yeah.
So, great. This is answered. Okay. Neerja Patra has asked if the management is not accepting the recommendation of the ICC, then whether it is required to give reasons for it. Well, that option is not there with the management.
That option is not there. The word of the ICC is final in the matter.
Right.
And if it is not if employer is not implementing, then employer finds himself culpable under the Act for non-compliance. Yeah.
Next question is, okay, another, this is a clear-cut question by Robert Vinod. Whether the external member can be the presiding officer of the ICC? Not possible at all.
Not possible.
Mr. Ashwini Fatke has asked, sorry, what are the actions that the ICC can take if the person is found to be guilty?
It is all given in the Act. It is all given in the Act.
Yeah.
And what it is if the, well, let me see now.
So typically there are these warnings, reprimands, these are censure.
Letter of apology, issuance of letter of warning, reprimand, censure, withholding promotion, withholding pay rise or increment for whatever X number of years, terminating services. These are amongst some of the things that could be done.
But probably the ICC will have to, evolve some sort of criteria on what is the seriousness when they recommend or a policy.
Abhyuday, that will depend on case by case, and as the ICC develops its own expertise in dealing with a range of issues that come up, they will be able to, it's very difficult to give a checkbox and say this happens and this is what you must do.
Correct, correct.
Members of ICC are mature people, they have put in many years of work, and they are able to understand and evaluate on the basis of the facts that are brought before them by both parties of what is actually, whether there is a complaint to begin with, a complaint is made out, number one, whether the complaint is false and malicious, and if there is in fact something substantiated, then what is the degree of that offense? Very difficult to say just offhand. That is the reason why they have given you everything from letter of apology down to termination of service. The full range.
Right. Another question is by Neerja Patra, whether the ICC can collect oral evidence or is it compulsory to collect written evidence? So,
how do you mean collect oral evidence? What does that
I
mean?
think she has not got the aspect correctly. So evidence could be oral, which has to be recorded in writing.
No. See, listen to me. Complaint is one document, right?
Right.
The reply to the complaint is the second document.
Right.
Now, what is evidence? Evidence is something to substantiate what has been complained about. Or
Right.
evidence is something to substantiate the fact that I have not committed such an offense. Right? So, that could be either that the complainant or the respondent is giving you some documentary. He or she is giving you some documentary evidence, in which case you will record to say that they have supplied XYZ documents by way of evidence, and or might say that, look, I want to produce 3 people as my witnesses who were present at that particular point in time, or who know about what has happened, or to whom I had told and discussed with. And then you would, as ICC, send summons to such persons and say, you please come and present yourself before us, and now you tell us. And then that oral testimony, which is also evidence, will be recorded as it is being spoken.
Right.
Yeah. Essentially, ICC is a court of record, briefly.
True. Okay, for now we have answered the questions. Any questions that follow we will take in course. We have around 15 minutes left for this webinar. So I'll proceed. I'll try to wrap up.
Yeah.
So we have already discussed about record keeping. Just one question: are there any pointers for the duration of over which past records have to be kept? Is there any practice you could suggest? Of course, the act is very new, so I mean, I would assume all records from now on should be kept. But
I imagine that till that person continues in your employment, certainly,
right.
And maybe a year or so after that, and that will end the matter.
Till the complainant and defendant both.
If the person is in your employment, and you know, just to be cautious and abundantly careful, you put it in for another year, unless there's a case that is going on in the courts, then you will have to maintain it, because the court can summon records at any time.
Right. And under which, so the ICC has powers to suggest reporting a complaint to the police, right? So when is the ICC, when should it exercise this discretion, or under which circumstances should it suggest this?
Look, if it is a grave matter, if the woman, the complainant, is desirous of approaching the police,
right,
then it is incumbent upon ICC and the employer to assist her in approaching the police. If it is an employee and the matter is sort of grave, then it is required for ICC to tell employer to immediately send in writing a complaint to the local police.
Right.
If it is somebody who is not an employee, then in any case automatically the matter will go to the police. That's what the law mandates.
Right. Two more questions have just flowed in. One is from Dr. Shivcharan Sharma. Is it necessary that the punishment is accepted by the accused? Of course, there is no requirement of any acceptance. This is a recommendation of the ICC which has to be implemented by the employer. So,
and there is if he doesn't accept, then he will file an appeal.
File an appeal. That's. And one question from Ms. Deepika Jain is that if an ICC member leaves the company and while the case is pending, then how should that situation be handled?
No, then you co-opt somebody else. Just the same way as it happens in our courts, Abudya.
Yeah.
Change of roster, new judge comes and deals with it.
Right. So that is an exceptional case where you'll have to accommodate that. She's asking this because
you deal with it as situations, arise.
And there might be some kind of rehearing required.
There might be some?
we might have to conduct hearings again, repeat the hearing,
Yeah,
so
it's
that the new
possible.
member
It's
is brought up
possible.
to speed.
Yeah, the new member might say that, look, I'd just like to meet these people again and hear separately from them as well. Whatever. I mean, you have to deal with the situation as it comes. But
Right.
of course, if you have your full case file ready, then
Right.
that new member would typically be expected to read the whole lot and familiarize themselves. If there are still some questions or some doubts, then proceeding can be arranged and that person can clarify whatever it is from both parties.
True.
Yeah.
So one question on interim measures. So the ICC has the option, right, to transfer whether it's the victim or the accused. That is up. Sorry.
I mean, they can come to this finding, yes.
Okay. So, I mean, what are the other options, interim measures that it can provide?
Look, the relief that is being provided in the law is a relief to the complainant. And
Right.
if in the view of the ICC,
Right.
there is necessity for the complainant to be provided some relief, then if you look at section 12 and read it with rule 8, you will find that, and of course the complainant can also make a request in writing to say that, can I please have such relief. And
Right.
this would be transfer of the complainant or the respondent.
Right.
All right. Or the grant of leave to the complainant for a period of 3 months. And of course, this is in addition to. Or to restrain the respondent from reporting on work performance, that means signing ACR and so on. Or writing a confidential report and assigning the same to some other officer. These are amongst the reliefs that can be granted to the complainant. And when the ICC writes its recommendation for providing these reliefs to the employer, then the employer shall forthwith, it says shall forthwith issue necessary directions and intimate the implementation of the said recommendations to ICC.
Right. So the employer has to confirm that the recommendations have been implemented.
Yeah. Employer is bound to follow and implement the recommendations of ICC.
Correct. So the question of what will happen if the complainant is working on an important project, we've already addressed this. This is irrelevant for the ICC, although if the employer requests, the ICC can also make a written request depending on the facts to the complainant, and if the complainant is willing to work.
Actually, this is something, look, this is something that the ICC can check up. I mean, they will know who the complainant is, right? And what position that complainant is holding, and what is the job profile of that complainant, right?
Yes.
So, typical thing would be, is there something important that is pending with you? Is there something that you're engaged in that actually requires your presence on the job?
Right.
How do you envisage that this should happen? Would you like to hand it over to somebody, or do you think that if we recommended that you be given leave for a little bit, that you can still continue to do with it? How do you feel about it? The complainant has to be asked.
True.
The complainant has to know that the ICC is mindful of, her sort of distress.
Yes, agreed.
So you build it into your preliminary or second term questions or whatever it is.
All right, and another question on whether parties can be assisted by a lawyer. And this is completely prohibited under the Act.
Absolutely.
So, and what are the obligations of the ICC apart from deciding sexual harassment cases? Some obligations pertaining to furnishing reports.
The ICC doesn't have any other obligations excepting natural justice, keeping proper record of it, recording the findings, making the recommendations, and generally performing their part of the task, in addition to always be cognizant of that fiduciary duty and absolutely be cognizant of the confidentiality that is required to be maintained by every member of ICC as well as every employee or person who gets into the knowledge of this matter. So if it is a case that, the ICC needs to consult, let's say, the lady's supervisor, who's really got nothing to do at all whatsoever with this, that person is automatically obligated to maintain that confidentiality. He can't be sitting in the canteen and discussing this with one and all.
Right.
Everybody, including the employer, is bound by that fiduciary duty then.
Right.
There is, of course, no way in which you can stop the complainant herself from going and talking to 10 people. But on the part of the ICC and anybody connected to the resolution of this problem, this complaint, are all bound by those particular sections which in detail describe what is the requirement of that obligation of fiduciary duty and confidentiality.
True. And there are confidentiality rights of the accused as well, right?
Of course, everybody connected, I said everybody.
Yes.
Yeah.
Just wanted to clarify for the audience, because sometimes we tend to think that, okay, only the complainant's name is to be kept confidential. That's not true.
Yeah.
Okay, this question on taking action for false complaints. So at what stage, is there a requirement to file a separate application for taking action against a false complaint, or is the ICC capable of starting that
No, I haven't
investigation on its
understood.
own?
What are you saying?
So the ICC has the power to take action against complaints which have been maliciously filed, these are false complaints. Now the question is that at what stage, can the ICC exercise this power on its own, or does it have to wait for a separate application made by the...
It doesn't. The findings of the ICC at the end of all the proceedings, and after ICC has evaluated and appreciated evidence, they will reach the conclusion through the course of those proceedings of whether the complaint has been false and malicious, or whether false evidence has been adduced in support of, by either party.
Correct. And in that
if
case,
they should come to the conclusion that either of this, then of course under section 14, you know that there are depositions.
Right. So
and the ICC is empowered to act in that regard without any further, intervention of any description. If in the course of the proceedings, ICC arrives at the conclusion that the allegation by the complainant against respondent is malicious, or that complainant or any person making the complaint on her behalf made the complaint knowing it to be false, or that the complainant or any person making complaint on her behalf has produced any forged or misleading document, then in reference the ICC may recommend to the employer to take such action against the complainant, including all the same things, letter of apology down to termination. Yeah, and this goes for also for the witnesses. If they come and give a false testimony, they produce some false documents, etc.
Right.
But one word of caution, and that is that, however, in making such decision, that means the decision that it's a false and malicious complaint or that it is false evidence, in making such recommendation to the employer, ICC will have due regard that mere inability to substantiate a complaint or to provide adequate proof need not attract action against a complaint, and malicious intent on part of the complainant shall be established after an inquiry following due process before any action is recommended. So in the middle of a proceeding, ICC cannot reach this conclusion. You have to follow that due process and evaluate and arrive at a finding.
Right. And a short, I would just like your brief inputs on the kind of training and infrastructural support an employer should provide to the ICC. So we have discussed this in an earlier session, but just for the sake of revision.
Well, ICC training that they require and need to understand is what is meant by due process and natural justice. So it is a matter of procedural implementation, and it is very difficult for me to I mean, I've been talking about exactly that all the way through. So difficult to encapsulate it, And infrastructural support, of course, you're going to, in any case, the Act says that there will be an ICC office. Now, if you look at the practical part of it, the complainant comes with her 6 copies. Who is going to receive it?
Right.
There'll have to be a secretarial assistance there. The summons, the chairperson says that, all right, please issue summons for Monday, 18th of November. Who is going to actually issue those summons? Who is going to inform the ICC? I mean, these are all logistic issues, so you'll have to think it through, and that the employer must provide.
Right.
Similarly, I imagine that if you have members who are co-opted into ICC at different locations, it's always better to already identify some secretarial resource who will assist in the matter.
Right. There is a question from Deepika Jain. In case an appeal is made against the ICC's decision in a civil court, who will be served the notice? The employer or the ICC?
The employer.
The employer.
Employer is expected to implement the act. It says so.
Right. There have been questions on how the ICC should decide the quantum of punishment. So I will just reiterate that that will depend on the situation, the pay scale, standard of living, mental agony, medical costs, a variety of factors. These have been outlined under the Act, and I think.
And also the actual offence.
The actual nature of the, yes.
Of the actual offence that has been made out.
Right. All right. I'm sorry. We come to the end of this webinar, and we've answered quite a few questions. If there are any other pending questions, I'll suggest the participants to either write to Mitali from CII, or they can mail us at esh@ipleaders.in. The ID is reflected on the screen. Before signing off, I would just like to say thanks to Mitali, and also introduce you to a cloud-based online training program for capacity building of the internal complaints committee and for sensitization of an organization's employees. So this allows employees to get sensitized on their rights and obtain online certification based on an online test. And for complaints committees, it allows them to, it gives them access to a repository of knowledge and sample formats and documents which they can use in the implementation of, in the discharge of their obligations while deciding cases. There are sample formats, decision-making guides, summons formats, order formats, decision formats, annual report samples, etc. If anyone who is interested may write to us on the ID and the phone number provided. And thank you, Ranjana ma'am, for taking out the time and helping us out in conducting this webinar and in answering the questions of the participants. We are extremely thankful to you for being there. I will hand over the dais to Mitali.